Attorney, I think this is also pretty obvious, not just to you, to me, but also to many of our fellow Filipinos. Most of these arguments, if not all, had been raised for her, or so it seems, by the very senator judges who were supposed to try this. Of course, itong huling argument na binabanggit niyo, di ba? Ang nag-raise niyan with great passion ay yung natalong kandidato sa pagkasenador na natapos na po yung termino, patapos na yung termino, si Francis Tolentino, hindi ba?
Yes. So the other thing is nagtataka naman kami na even after the Senate adjourned its session, the Senate President keeps talking and the Senate spokesperson keeps talking about a motion to dismiss. Uh, and that it is possible under the Senate rules that a motion to dismiss can be heard and can be decided by the impeachment court. That obviously is very wrong. It is very clear in the Senate rules that there is no such thing as a motion to dismiss. Dalawa lang yan, trial to convict and trial to acquit. We've said it so many times. But the operative word is trial. Denial, a hearing and the motion to dismiss is not trial. They want it, they want to have issued the question of jurisdiction, and they will have their day in court. Let the prosecution present its evidence and let the defense present its evidence. Precisely, which goes to a very important point. The answer had zero evidence. Where is the bloodbath that VP Sara said? We will have a bloodbath. We have evidence, blah, blah, blah. We will go to trial, in the words of the VP. Now she's saying in her answer, uh, what is her evidence? None, zero. She has not presented any controverting evidence. Although she probably will say, why will we present? Because wala namang kayong jurisdiction. But precisely, the answer is there for you to show to the public what you have long been saying, that you have evidence to prove your innocence uh, on many of the charges filed against you. So where is the bloodbath? Kami nga mga volunteer lawyers, ang tawag namin sa motion, sa answer na yan, bubble bath.
Bubble bath.
Bubble bath, hindi, kasi hindi ba ang bubbles, pag pinitik mong gayan, disappear. And that's exactly what this is all about. It's all bubbles. Bubbles and air. There is no bloodbath of evidence. And her answer denies everything. Lahat ng sinabi sa articles of impeachment, dininay niya. Ang inadmit lang niya yung personal circumstance niya na she is who she is, her residence, and her position in as vice president. Which in fact she should deny that she's vice president because she is not acting consistent with what a vice president should be doing, which is to be accountable to your public office. She's now, in less than a month, she has traveled 4 times. What is her? What does she do? She's destroying the government, which she is supposed to serve as an executive. She's destroying the trust of the people who she is supposed to serve. So sana sa answer niya, dininay na rin niya na vice president siya. Kasi type niya maging designated survivor. She already deems herself as the designated survivor of a bloodbath that we don't even see is happening.
Ordinarily, how should this kind of answer be treated by a court? 'Di ba inisa-isa niyo 'no, medyo ano lang siya, blanket denial, 'di ba? So,
Blanket
sometimes
denial yan.
medyo absurd yung mga binabanggit 'no. So, how should this be treated ordinarily?
It should go to a trial. It should go to a trial because if she's saying that there is no evidence against her, first she's saying that there is no jurisdiction uh, of the impeachment court, then she should present it when it's her turn to present evidence. No? Or if there is no evidence, then to argue her motion to dismiss. It's like putting the it's like putting the cart before the horse. Di ba?
Hmm.
Dapat the horse is always in front of the cart. Ang ginagawa ng VP, she wants the cart in front of the horse. Let's try first this case. The prosecution will present all its evidence. You have the opportunity under due process. You have the opportunity to cross-examine, to examine the evidence, to examine the credibility of the witnesses during a full-blown trial. As a matter of fact, VP Sara should not be scared of a full-blown trial because she has senator judges who will object to questions for her. Senator judges who have said no matter what the evidence is, they are Duterte, for Duterte, even without hearing the evidence. So what is her anxiety? She will have senator judges there who will do her own objections for her, who will act as defense counsel. I hope I'm not being disrespectful to the Senate as an impeachment court because I am an officer. We all are lawyers, and lawyers are officers of the court. But to be respectful to a court, they must also deserve respect. No? They must also act with the cold neutrality of an impartial judge.
Mm.
That is the... So, trial na muna. Mag-trial, that should be the proper procedure. You present the trial for the prosecution, present the evidence, then trial for the defense. If after that, uh, the Senate will say acquitted, or it could also say, yeah, we have no jurisdiction over this, then they do it after trial. So that does not preempt the hearing of the motion to dismiss, uh, but it should be during her term to present her defense.
Mm. Okay. So dito mukha bang nakikita niyo na ang gustong pigilan dito yung actual trial para makita yung mga ebidensya?
Yes, because sa trial, all the modes of discovery are allowed. Ano yung mga modes of discovery? Pwedeng mag-issue ng subpoena. The prosecution can ask for subpoena for bank records. I think dun sila natatakot, yung subpoenaing of the bank records. The subpoena of the documents in the appropriate government agencies to show the chain of funds, no? The flow of funds. Where did the funds end, no? Subpoena the names. We can Prosecution can subpoena the actual names because government agencies, and here the office of the vice president and the department of education, when she was secretary, should have the real names of real people in a vault because sila yung tumanggap, sino yung tumanggap ng pera, ano yung mga pangalan nila. That can be subpoenaed because she's saying that they're not fictitious, they're confidential names, and aliases, but they're real people. That can be subpoenaed. Her bank accounts can be subpoenaed. Sabi nila, and they're hiding behind the bank secrecy laws. Again, that's gross ignorance of the law. Because the bank secrecy laws have exceptions, and one exception is impeachment proceedings. Banks can be required by order of an impeachment court in an impeachment proceeding to produce bank accounts. So this whole thing of motion to dismiss is motivated by fear that she has no evidence to contradict the strong evidence of the prosecution. She is just relying on her allies. She's relying on AI. She's relying on getting support from our OFWs abroad. She is relying on fake news. She is relying on distortion of facts. As a matter of fact, we should remind the vice president that she is an officer. She is a lawyer. And not only she has a duty as a public official, she has the duty of candor, honesty. All the cases cited, all the cases cited in the answer ad cautelam were false and misleading cases. Kagaya ng sinasabi niya, yung Francisco case on the
Mm.
one bar rule. Sa Francisco case naman, unlike dito sa current impeachment case, nakatungtong sa Committee on Justice. It was verified, a first complaint was verified, was filed, and then went to the Committee on Justice. So that counted already as an impeachment complaint. So when a second impeachment complaint was filed, that that was already barred by the first. Kasi referred to the Committee on Justice. Dito naman yung tatlong earlier complaints were verified, meaning signed and sworn to, but not referred to the Committee on Justice. So what was that? Misleading. They're citing cases in the hope that the senator judges will not read the case. They'll just rely on the citation.
Mm.
Pero
Okay.
clearly not applicable yung mga sinasite nilang cases.
Yun nga rin, yung case na yan nailatag na rin ng isang senator judge yan para kay Vice President Sara Duterte, no? Quite curiously. Anyway, etong ano po, finally, anong sagot ng House Prosecution Team dito naman sa second requirement ng Senate Impeachment Court? Yung pagsasabi dapat ng 20th Congress na okay pa kaming ituloy ang impeachment complaint.
Well, I cannot, we cannot preempt the 20th Congress, no? But first of all, the legal argument there, if you're talking about strict legal argument, is it is continuing. If the court assumed jurisdiction, jurisdiction will continue as an impeachment court. So whether it's 19th Congress, whether it's 20th Congress, that impeachment case is alive because nag-vest na ang jurisdiction with the impeachment court, not with the 19th Senate, not with the 20th Senate, but with the impeachment court. But I think it would be prudent if since the public prosecutors have already said that they are officers of the court, no, the public prosecutors acting as prosecutors should comply with the order of the impeachment court. And if the second order requires that there should be a determination by the 20th Congress that it will continue, then there is no harm in certifying that 20th Congress, pursuant to its belief that this is continuing, will proceed with the impeachment case. No? Ang dapat lang gawin ng 20th Congress, I think, no, is to designate two additional public prosecutors
Mm.
because sa 19th Congress, dalawa ang hindi nanalo sa eleksyon. So they have to be replaced. And that is where the 20th Congress will have to name two additional prosecutors to complete the 19. And it's public knowledge that that would be Congressman-elect Laila De Lima and Congressman-elect Shell Chok. No?
Mm. Pero technically ba pag nagpalit ng Kongreso, the next Congress can tell the impeachment court na we're withdrawing the articles of impeachment filed by the previous one? Eh kung na-acquire na yung jurisdiction at dire-diretso na dapat?
No, it cannot. That's why it is a ridiculous requirement. It is absurd. It is absurd and it betrays ignorance of the law. But it is not for the public prosecutors to argue against an impeachment court, no? But maybe the clear way to avoid the technicality is just for the 20th Congress to certify,
Mm.
even if it is of the belief. The public prosecutors are of the belief that it is totally unnecessary. It will, I think, comply, or it should comply, as officers of the court. There is no harm in doing that. Although, by requiring that, that betrays the bias of the Senate, no? The 18, hopefully the 18 who voted in favor of this order of the Senate will be open-minded when they see the strength of the evidence of the prosecution and the lack of a bubble bath from the defense.